Hello, everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, your trusted source for immigration attorneys, expert legal insights, and real-time conversations with experienced immigration attorneys. My name is Max Castro. I'll be your host for this important session, RFEs and NOIDs, responding to requests for evidence and notices of intent to deny. When navigating the U.S. immigration system, nothing creates more stress than receiving a notice from USCIS questioning your case. Whether it's an RFE, a request for evidence, or an NOID, a notice of intent to deny, these letters can be intimidating and overwhelming. Applicants often wonder what went wrong, how to respond, and whether their future in the U.S. is at risk. The truth is, how you respond can make the difference between approval and denial. That's why we're here today to provide clarity, confidence, and practical strategies to help you or your loved ones handle these notices effectively. We are honored to be joined by Attorney Vilerka Solange Bilbao, the founding attorney of Bilbao Law and the passionate advocate for immigrants and asylum seekers. With her background in psychology and years of legal experience, she combines compassion with strategic precision with representing clients. She also serves as the board of AILA's Central Florida chapter as liaison for ILA's National Health and Wellness Committee. As an immigrant herself, Attorney Bilbao understands firsthand the fear and challenges her clients face, and she brings empathy, resilience, and creativity to every case. You're welcome, Attorney Bilbao. We're thrilled to have you to join us today.
Thank you, Max.
Before we dive in a quick but important reminder, Immigration Question is a two-in-one platform that connects users with licensed immigration attorneys. We are not a law firm and are not affiliated with AILA or USCIS. All legal services are provided independently by attorneys within our network. Let's dive right in. So to start, could you explain what RFEs and NOIDs are and why USCIS issues them during the immigration process?
Yes, Max. So an RFE is a request for additional evidence that the government, USCIS, will ask of you, and it's a written document that you will get in the mail. If you have an online filed case, sometimes you can also receive that through the online filing portal, but for the most part, it is a document that comes in the mail. The NOID, which is, as we call it, the Notice of Intent to Deny, that is a document that is not necessary to give to a case. And it's towards the end of a decision when an officer has gone through your evidence and has a reason to deny. And so they have this optional form that they can provide to you saying, hey, this is everything that I've reviewed, this is my analysis, and these are the reasons why I would be denying. Both the RFE and the NOID are going to get a specific time period for you to respond to, and you have to make sure that you do meet that deadline. And then when you are responding, you are providing back evidence and arguments to complete either the request for evidence or to maybe change the mind of the officer about why they're going to deny your case.
Understood. Thank you very much for expounding on that. From your experience, attorney, what are the most common reasons applicants receive RFEs or NOIDs?
So the most common reason is because people do not necessarily send all of the required evidence. So for example, there might be a medical waiver or document or exam that you need to present with your case, and that is in the instructions, and you did not read the full instructions and sent your case in any way. USCIS might give you a receipt for it and then issue you that request for evidence, seeing that they are missing that initial piece of evidence. So those RFEs come in rather quickly when you're missing something, and it's because when your case arrives to the service center, which is basically the office that processes the application that you send in by mail, the officer has a checklist of the things that they are required to have to process the application. So for example, your check. If you do not have a check, for the filing fees that are correct for your form, they're not going to even issue the receipt. But once they have that check and they issue the receipt, then they're going to be looking at whether you have the required forms, whether each of those forms then has the required evidence. So When it's required evidence, it's going to be a relatively fast request for evidence that you're going to get, maybe within 1, 2, 3 months of getting your receipt. The other big reason is because that people receive requests for evidence may be because the evidence is outdated. So, for example, in a marriage petition in I-130, you might file that application in 2022 when you married your US citizen spouse, but there's been no decision. Now it's 2024, 2025, an officer is looking at your evidence and they want updated evidence to ensure that you are still married to that individual that you applied with in 2022. So sometimes it's a matter of updating your case, the reason why they're issuing that request for evidence. There is a third big reason that I think a lot of people may not know, but it's that USCIS makes errors constantly. So one big error that occurs even at the service center level might be when they're scanning some documents in. You might have sent in that birth certificate that they are asking for, but when they scanned it in, for some reason, that page did not get uploaded properly. And when the officer's looking at it electronically from 2 or 3 states away, they don't see a birth certificate. So they issue you an RFE for that. Now, USCIS is using some AI technology that they haven't been 100% transparent about what this AI technology is. But some of the trends that we've seen as attorneys and through some of the things that get reported to AILA is that there is evidence that people are submitting with their packages that does not get scanned in properly. And then there's requests for evidence for that. And some people sometimes make the mistake of sending a letter back saying, hey, I sent that in my original package. And they answered it. But never do that. You need to send them the evidence. If they say they don't have it, it's because they don't have it. So, there could be a myriad of reasons why they're asking evidence, but it is extremely common. And one of the things that people can do is if you're working with an attorney, the attorney is helping you flag what are all these potential things that they could ask for, so we can just give it to them up front. The case takes longer to process if there's requests for evidence in the middle.
Understood. Thank you very much for shedding light on that, attorney. But when responding to RFEs, how can applicants ensure their evidence is strong, well organized, and directly addresses USCIS's concerns?
Yeah, so I think this is a challenge for many people because there's things that we just assume. For example, we did a NOID recently where an individual was applying for a green card but had done a little lie, a misrepresentation in his visa application years ago to come into the United States. And because of that, he was being charged basically with fraud in the immigration system. If you lie or say information that's not 100% the truth, they will hit you with one of these fraud things. And so in order to overcome that, we had to prove that him and his family would suffer extreme hardship if he wasn't given his green card. And so how do you prove extreme hardship to your spouse? If you have to go live in another country. My client is specifically from Cuba. If he had to live in Cuba and the wife had to live here with the children. And so sometimes you need to get creative in how you expose the harms that people are going through. Because to me, it's very obvious that if my spouse lives in another country, a communist country, where there's no medicine, where there's not a lot of food, where there's blackouts 23 hours a day, I see that very clearly as extreme hardship. My child won't be able to be with their father. They won't be able to spend Christmases, but you have to spell that out for the officer. So a declaration explaining all of the reasons, not just one or two or the main reasons, explaining everything is really crucial. And that's where I say you get creative because you start asking the family about things that they may not even have thought about. Like, okay, well, where are you guys going to spend Thanksgiving if he has to move to Cuba? Where are you guys going to spend Christmas? Are they going to be able to see the grandparents? Can the grandparents travel back? Are the children now maybe going to be forced to go back to a country where they can't speak the language? Let's talk about your medical issues. Who has medical issues at home? Would they be able to get that medical issue when they're visiting dad abroad? What happens if your child has an asthma attack in a country that has no medical issues? So you really get very in depth with each family to figure out what that evidence is going to be for each family, rather than just, oh, it's going to be extremely hard. I'm going to miss my husband. He's going to be in Cuba and I have to be here, right? So that's where the strong evidence comes in. It's a very detailed declaration or statement from all of the affected parties in situations like that. Sometimes the evidence is very basic in terms of they're just asking for birth certificates, right? So make sure that those birth certificates don't contain any errors. Make sure that you can read them. Make sure that you're not sending a copy of a copy of a copy, or a printed version that, the birth certificate is on a table and there's a mug and a pen and something else and the officer can't read it, right? So making sure that your evidence is clear. If it's in a different language, we're required to submit certificates of translation. So making sure that those are accurate, that there's no errors there, that it has the correct certification. It's just very detail oriented. That's what it is. I like, as attorneys, we always do a table of content. Here's my list of everything that I'm including. And so that's my checklist of everything that we have, making sure that things are in order, that things have a page number at the bottom, because that helps the officer who's reviewing your case. Officers have very little time to review cases. They are reviewing hundreds and hundreds of cases. And so if you make it very difficult for them to find a document, they might not find it and they might deny you, even though the document might have been in there. So it's your job to make the application easy to read. Even the language that we use in our letters, I'm not making all this fluff, gorgeous poetic language. I'm making it very clear so that the officer can read it, and it's not confused when they're reading it. And obviously, the more complex the case is, the more it requires those skills. But even in an I-130 marriage-based petition, which is a lot of what people do on their own, sometimes there's explanations that need to happen for the officer. Like, why does a person have a child with 2 or 3 different spouses within a 5-year period if you're married to this person? You might have to have an explanation for that, even though that's very personal, but it might make the officer not question your relationship if you put it all up front and provide them with what happened, right? And this is our family situation, a dynamic modern family, but this is what it is. Then have the officer question and put your file aside and have it sit there for 2, 3, or 4 years. So it's hard to, I guess, give just very direct parameters, because the evidence is going to be so different for every single individual and every single case.
Thank you very much, attorney, for that very well thought out answer. But when it comes to strategies, how do strategies differ when responding to a NOID compared to an RFE, given the higher stakes involved?
Yeah, so they both have very high stakes, because if you don't respond to an RFE, your case is going to get denied. Or if it has an improper response, it's likely going to get denied. You're not likely going to get an RFE and then a NOID. It's usually one or the other. So the stakes are high, because you're getting a denial, basically, if you don't do this correctly. I think the strategies differ based on, at least as an attorney, I have this case since the beginning, and I have all of the information that I can work with, and I've already been anticipating this potential problem, or whether it's a case of somebody who comes in through the door today with an RFE or a NOID. It's so much harder as an attorney to respond to an RFE or a NOID when you have not been dealing with the case. And the reason is, usually we can identify potential issues in a case. And so we know where the officers are coming from. We know that this is a question, and we've already possibly prepared the client on what to do while we wait for this RFE. So a good example is, I do quite a lot of marriage cases where people are already in immigration court. And so if you just got married to a US citizen or a legal permanent resident, you can file right away for your marriage petition, the I-130. But a lot of people wait up until they have 2 or 3 years of evidence to do it. And my personal view on it is start the petition as soon as you're married. You're not going to have all the evidence. You're only going to have the evidence of when you guys were dating, maybe when you moved in together. But in a year, we can update evidence and provide them more evidence. And you're in line. You already have a priority date. Your case is already being processed. You're in the system, right? So at that point, if I get an RFE within that year, people who were just married, I'm already letting them know what are the things that immigration is going to be expecting. Like, hey, next year, you guys is going to be the first year you have to file taxes together. Make sure that gets done and it gets done timely. Let me know if you have any questions. As you guys join your finances, let me see those accounts because immigration is going to want them. So when you've been working with an individual already, you may already have the evidence anticipating that RFE coming in. And then it's just simply putting it together and answering versus an individual who you haven't been working with and they come in with an RFE, it might be really difficult to comply with the timeline. So usually the RFE gives you anywhere between 30 to 87 days to respond. So that's the window. Sometimes you have 30 days. I've seen, for example, requests for evidence for police records from your home country, and they only give you 30 days. That's a real difficult one to meet, even if it's just that document, because you may not be able to get someone back home to go get that report, get it stamped if it needs to be stamped from that country, and then back into the United States, and then usually translated and sent to USCIS within those 30 days. So if I'm working with a client since the beginning, I'm already telling them, hey, make sure you have this document. I don't want you to get this RFE and not have it ready, right? So that's one. That's on the short end of the days that you can respond. The ones that are closer to 87 days, of course, it's almost 3 months. You have a little bit more time, but it's still not enough time if you need to request documents from the government. So this happens often with people who have a lot of visa entries, maybe came to the United States, and they don't have all their entry and exit dates from the United States, all their trips. Or maybe they listed trips on their applications and they're incomplete, or immigration has different dates. So they might send you an RFE to say, hey, our dates of your travel are different than what you have. We need an updated list. If you need to request that from the government, it takes them at least 6 months to provide that to you. And so you don't have time to respond to an RFE that's 87 days long. So it's very important to almost flag all these issues beforehand so that you can already resolve them prior to the point of getting an RFE or getting a NOID.
Understood. Say, for example, like if someone is already covering how they could prepare, what are other common mistakes applicants or even attorneys make in responding to these notices, and how can it be avoided?
I would say one big one is waiting until the very last day to file it, just because there is no room for error at that point. And I've had it happen to where we have timely filed it, but the officer does not have it on their desk on that day. And they are one of these officers that may be more strict. It's not on their desk on that day. They're hitting deny case, right? They're clearing out their cases very easily. And so even though you may have complied, you did it at the very last minute, that officer won't have it on their desk in time. So that's one issue that can come up. Not saving copies of what you sent, and also not saving your receipts and delivery receipts and confirmation that USCIS received a package. Because let's say that you did respond in time and the officer still denied your case, you have the opportunity to reopen that case, do a motion to reopen. It's a form that's available. Send in your receipt, say, hey, I did comply with the deadline. Here is my proof. Here is a copy of the answer that I sent over. You should approve my case. That happens very often. It's infuriating, especially when you turned it in time and you have that proof. But if you did not have the proof, you would have to start over. And some processes take years. So those are things that, even though they're small details, you're like, okay, I did it a week early, 2 weeks early. How do you prove that on the back end if the government makes the mistake, right? It's still on you. You're the one interested in the benefit. So keeping receipts of everything is super, super important in this world.
Thank you so much, Attorney Bilbao. To everyone joining us from Facebook, YouTube, and LinkedIn, thank you for being here. Whether you're a legal professional, community advocate, or someone just looking to understand immigration better, we are grateful to have you. And if this is your first time with us, welcome. We are immigrationquestion.com, a meeting ground between immigration attorneys and individuals seeking answers to immigration questions. Our two-in-one platform is built with outstanding features to help simplify the immigration process. Though we are not affiliated with the AILA, we are trusted by many AILA attorneys who use our platform. With immigrationquestion.com, you can also ask your immigration questions for free in any language and get connected with a licensed attorney for legal guidance. And yes, just like many of our users, you may also receive a free confidential initial consultation. Just visit www.immigrationquestion.com to learn more. And it gets better. We've just launched our new mobile app designed to make access even easier, whether you're a user or an attorney. We have amazing news. Immigration Question is now BBB accredited, and we're proud to announce that immigrationquestion.com has earned Better Business Bureau accreditation. We now bear a mark of trust built on BBB standards. Honest advertising, transparency, honoring promises, and handling consumer concerns the right way. This recognition shows our ongoing commitment to serve you with integrity. Attorney Bilbao, as a respected immigration attorney with a passion for immigrants and asylum seekers, what are your thoughts on the impact of Immigration Question is having on the immigrant community and on immigration attorneys just like yourself?
Yes, I think it's important that people are able to ask immigration questions, and that they're connected to attorneys. This is a legal world where there is a lot of just shifting landscapes, right? One day there's one rule, tomorrow there's another. Today there's a new program that the administration added, and tomorrow it's gone. So it's very important to be up to date and to have a connection to an immigration lawyer if you are an immigrant. The internet is very full of a lot of information. Some information is outdated by the time that you see it. And so outdated information can be catastrophic in relying on that with your immigration path. So it's very important to connect individuals, and then to do things like this where we're providing information for people so that they make better choices about their cases and they're informed. Getting an RFE is not something bad. People get them, attorneys get them. Sometimes we know that the case is going to get this, but preparing for it and being able to clarify the story for the officers about what happened, about what your reality is. Because I'll be honest with you, the officers do not have time to investigate your case. They do not. They are looking at the official records that they have as a government on you, which are usually arrest reports, driver's license applications. If you've been in a bankruptcy proceeding, if you've gotten divorced 10 times, if what they have on as government records is what they're looking at, and then what you are providing to them. They are usually not doing a more in-depth investigation. They take their time because there's millions of applications pending. It's not because they're investigating you personally. So if we don't do that work and put our life on paper for them, it's very hard for the officer to really understand everything that's happening. I'll give you a good example here. We love to include pictures in our applications. Even if it's a waiver, especially if it's a waiver. If I'm saying that, there's going to be a child that's going to be without their parents for a period of 10 years, and we want to get that waived so that they can get their green card right away, I'm putting a picture of that child, so that the officer realizes this is a human being. This is a real life person, a person's life that's being affected. And those are little details that make or break your case sometimes. If the officer is bored while they're reading your evidence, if it's disorganized, if they can't even know what they're looking for, you're just making it harder on yourself. And so teaching people that they can make these things, small changes, is going to increase in people getting approvals, which is at the end what we want, more immigrants with legal status in the US.
Much appreciated, attorney. Thank you for that. We're glad to know that both attorneys and immigrants benefit immensely from our platform. And before we dive into the Q&A session, what practical advice would you give to immigrants who feel discouraged or even overwhelmed after receiving an RFE or a NOID?
So one, I would say don't take it personally, even though I know it is a personal notice with your name about extra work that you need to do in your case. But there are many reasons why this could be happening. One could simply be a scanning issue. At AILA, one of the things that we do is we monitor trends that happen with the agency. And this is something that we have worked with the agency for a number of years, to where applicants show, including attorneys, hey, I sent in that birth certificate, or I sent in that divorce certificate. It happens a lot with marriage and divorce certificates. It's in my application. They didn't see it. And the officer doesn't have it. That's why they're sending a request for evidence. It might have been a scanning issue. It might have been that the person scanning your file dropped some coffee on it and just didn't scan that page and scan the rest of it. Who knows? But just do the response for it. Respond appropriately, always with a lot of respect. You might say, I mean, we say it, hey, this was submitted in the original package. Here's an additional copy for your reference, right? Just don't say, hey, we already submitted that, because the officer clearly sent that RFE because they don't have it. Sometimes, and not always, we send additional evidence that the officer didn't request. So in a marriage case, for example, maybe the officer requested for additional financial documents of the couple, a case maybe that's been pending 2 or 3 years. Well, at that point, I have the opportunity to also show them that for the last 3 years, this family has been spending Christmas together, or they've been traveling, or they opened up a business, or now I have a really good letter of recommendation from their church pastor. So you don't always need to only answer what's there. You can supplement evidence, because if for some reason that officer is not convinced by the evidence that you gave them, that extra evidence might actually provide more clarity that you've met all the requirements. The other thing I would caution about as practical guidance is to be careful when you are submitting police reports for any incident where your case was dismissed or discharged and you actually were innocent of the crime. So police reports are not always required evidence that needs to be submitted. And often USCIS will send you a request for evidence for things that are not required under the law. They want more, right? And they want more because they might use it against you. Especially in the context of an arrest, especially in the context of a police report. So let's say that maybe you were driving really late at night and you got pulled over and you got charged with a DUI. But at the end of the day, you were not convicted of the DUI. Those charges were dropped. Your police report is going to have very negative information because that's why you were arrested for the DUI. The officer might have put in there that you had bloodshot eyes, or that they saw you swerving in front of another vehicle that may have been dangerous. So that information may not be something that you want USCIS to have. And if you were actually found not guilty, or your case was dismissed or discharged, then at that point, that is not a required document. So I would be very careful for people who are especially representing themselves in submitting police records to immigration, because that becomes a part of your permanent record. And so you don't want to be submitting evidence that's not required for you to submit. And sometimes we have to fight them on it. Sometimes we have to say, we understand that you may want information about what happened. Here's a detailed statement from the client and the case disposition from the court that shows that this DUI was in fact dismissed. This person is not guilty of this. And so it can, whatever allegation the police said that they cannot be used against him, a court already ruled on this. So sometimes we have to fight them back. And so don't be afraid if that is what you have to do. But that's, again, why working with an attorney since the beginning helps you, because we're already flagging that. since the beginning. If somebody tells me that they've been arrested, and even if they don't tell me, I do fingerprints on all of my clients. This is how I know exactly what happened and exactly what the government also has on them. So we can anticipate a lot of these questions, but I'd be very weary of providing them additional court records, additional arrest records, because sometimes the law doesn't require you to, and you don't want to mess up your case. Maybe it doesn't mess you up for the first case, but at the point where you become a citizen or where you have to get your green card, that may be an issue. So it happens a lot with the work permits. So in the work permit, there's a question, have you ever been arrested? If you have, you are supposed to be sending in certified copies of the case disposition and sometimes the arrest. So it happens in that context and you just want to get your work permit. Well, you don't want to also mess up the rest of your case. So I would big asterisk on that portion to be careful there, because you could have a lot of problems.
Thank you so much, Attorney Bilbao. That is definitely insightful. Just going back in, if you're just joining us, we've been having an eye-opening conversation with Attorney Bilbao on today's topic, RFEs and NOIDs responding for requests for evidence and notices of intent to deny. We're now moving into our live Q&A session. So if you have a question for Attorney Bilbao, now's your moment. Drop your question in the chat or call us live at 516-703-3483. That's 516-703-3483. Great. So we already have our first question in. Let me read it for you. It's coming from Damian Thompson. My EAD case is outside of normal processing time. Did inquire 30 days, but still no response. I will move to another state in 2 weeks. Will this slow down my case, or will it speed up getting frustrated?
Yeah, so I understand the frustration with USCIS. You definitely have to have some patience with them. So it depends on what your EAD category is. Your EAD is your employment authorization document. There are certain categories where it is mandated by statute that they respond within a certain amount of time. Other categories, not so much. So this sort of question answer here is going to depend on what category this person is at. Damien, you did an inquiry online, so that's good. The other thing that I would say is you could call the USCIS. They have a 1-800 number. I think it's like 375. Find it online, just put USCIS 1-800 number, and you can call with your receipt number and explain the situation, that the case is outside of normal processing times, that you need your EAD to be able to work lawfully in the United States. Sometimes people even need their EAD to renew their driver's license. So that might be another reason why you might need to get it. If you are going to move, you are required by law within 10 days to change your address. And so you will need to change your address with USCIS and change it also within the EAD category, the EAD application. So you are required to change it either way. What can happen practically is that the government might approve your EAD and still send it to the old address despite you changing your address timely with them. So it's important that wherever you're living now, that you leave a contact, you leave an address, maybe even give them a nice little gift card so that when that document arrives, they can mail it to you, right? Because it is very possible that they will send it to an old address. It's also true that USCIS sometimes sends it to an even older address that the person had. So sometimes they sort of mix up the addresses in the system and they mail it to a previous address. So you do have to be in contact, just on top of it. I'm looking at your case status all the time. And if you do not receive your EAD in the mail correctly, you need to be contacting USCIS immediately about that. Usually there is a notice on your online portal that says that the EAD has been delivered. And if you see that and it's not in your mailbox, it's not in your old mailbox for your old address, then you need to be contacting USCIS. I will say, if you are at that point, it takes a long time for them to reissue another employment authorization document. So you may need to ask for that to be escalated to a supervisory officer on the phone. The 1-800 USCIS phone number is not always very helpful. They are not immigration officers. It's a call center. So what those what those representatives can do is very limited. They cannot make a decision on your case. What they can do is they can put notes for the officer to review the case, but they are not immigration officers themselves. So sometimes all they're going to do is put a note that'll go to the officer handling the case. And so it's important to know that. If you have asked for something several times, I would ask to speak to a supervisor on that 1-800 phone number. And then sometimes that gets your message a little bit farther along. But none of these things guarantee that USCIS will actually act on your case. Now, an EAD being outside of normal processing time is super common. And not only an EAD, really any application these days, USCIS is usually very late. The processing times that they publish are 80% of their cases. They try to finish within that time frame, but that's just the majority. There's some cases that are going to be way longer. So if you've had problems with your EAD before, I would say talk to your attorney to see what other problems there could be. And one possible solution is to request a USCIS FOIA. So FOIA is a Freedom of Information Act, and this applies not to the EAD, it applies to everything with USCIS. You can request a copy of your immigration file, and you can request specific things or you can request your whole file. It takes at least a month for your FOIA to come back from USCIS. And sometimes there you can see the notes that an officer is writing, or you can see the things that are being flagged. And that may give you an understanding of what it is that's missing. Right? Maybe they're still waiting on your fingerprints to come back because you have really bad fingerprints and they are going to request for you to do more. And so that may trigger you to request, hey, can I get another fingerprint appointment if this is the holdup? So unfortunately, sometimes we have to do the work for USCIS to move the cases along. But that may be an avenue if your case is just taking a very long time. But this is very normal, Damien. I feel like there's millions of people dealing with issues like this of delays with USCIS.
Thank you, Attorney Bilbao. And thank you, Damien, for sending in that question. Let's try to move on to the next one. Okay, so we have a question. USCIS sent an RFE asking for evidence of my employment and achievements for an EB-1A petition. How do I know what counts as strong proof of extraordinary ability?
Yes, so in the EB1 category, there are 6 different categories of sort of evidence that you can provide to immigration that are listed in your instructions. So if you've won awards, have you been published, have you been recognized by another organization? The reality for the EB1 world, and honestly the employment world as well, is to give them as much information as you can. So in the extraordinary ability, you are trying to prove that you are someone outstanding within your field, whether it be medical field, technology field, legal, the arts, the sciences, business. So you are looking to show how you are different than other people, how you're contributing to your industry. So if you've talked somewhere live, if you've taught a panel or taught at a university or been published or are on TV or have done a show, like you want to show them as much information as possible. The strongest thing that I can tell for EB1 clients that we usually start with, at least in my firm, is to do a very detailed CV curriculum of since high school. When you graduated high school, I want to know your whole story. What have you been doing? What special courses have you been doing? What special training, extra trainings do you have? Licenses, appearances in places. And so once you look at all that, then you want to decide, you don't have to send them everything, okay? It might be too much, but at that point you might want to decide, okay, this is superior than that. This is better than that. Let's say somebody who has only been published on online magazines, you might want to decide, well, which of these magazines has more reach? Which one has more exposure? Which one provided me with, a better opportunity? It's very, very independent and fact dependent on the person. But awards are big. Any of those 6 categories, if it fits in those 6 categories, you want to be giving it to them and not just one in each. Because if you're extraordinary, the idea is that, like, it's almost unbelievable. Wow, you're a great person that we want, a great talent that we want in the United States. So give them more. And I'd say another thing that's super important, sometimes it's working with a consulting agency or somebody that does sort of marketing, and making sure that you have a good online presence. If an officer Googles you, does a quick Google search, are you online? Right? And you might not be, depending on certain industries, but for the most part in 2025, if you are not online, we have a big problem. How can you be an EB1 and not necessarily be online, right? It doesn't mean that you have to have 1,000 followers or 1 million followers. That's not what they're looking at. But if you're published in a newspaper, that should appear online. If you've done a TV appearance, that should appear online. Even if maybe you posted it on your own website and said, hey, can I have a copy of the video when I appeared there? But make sure that these things are available, because the officer won't receive audio, they won't receive video evidence. Everything is paper, and then they can Google you, right? So you want to make sure that you are present online. And if you have a slogan, a tag, a business, that those things are also present. If you have a paper that's been published, if you were at a university as a professor, all those things should be online. Your track record should be viewable.
Great. Moving on to the next question, we have Lily. I filed a VAWA petition, but I'm being asked for objective evidence of abuse. What can I provide if I never went to the police?
Yeah, so I love VAWA cases. Some people believe, so VAWA is a Violence Against Women's Act, and it allows for family members of US citizens or legal permanent residents who are able to petition you, but who don't, because there's abuse. There's some sort of thing that happens either in the marriage relationship, parent-child relationship, that doesn't allow them to petition for you. And so VAWA allows the victim in these situations to apply themselves and say, look, I'm applying for myself. I do have to prove the abuse happened so that I can apply for myself. But I should have been able to apply with my spouse, for example. They won't do it, and these are the reasons why. And a lot of people think that VAWA is only physical abuse, or only when there's a domestic violence charge against that person. And the reality is that you can definitely win your VAWA case without a police report and without being physically beaten. There are a million ways that someone can abuse another person. The most objective evidence that I think that you can do is going to a psychologist and getting evaluated. It doesn't have to be that you are receiving therapy constantly, even though if that is something that you need, that's definitely objective evidence that you've been affected by this person. But there are psychologists who will do mental health evaluations for people. And when they look at your history, they will denote what happened with that past partner and whether that objectively meets the definition of abuse and cruelty, which is actually what immigration looks at. So there could be financial abuse, there could be emotional abuse, there could be cheating is often a form of abuse. There could be matters in which people control. And there's a very good, what is this called? Chart that's called the power and control wheel that psychologists use. There's different versions of it, but it explains how there's different areas in which a person can abuse you, control you, manipulate you, right? And if those things are present in the relationship, going to a psychologist and getting that from a medical doctor is one of the ways that you can have objective evidence. The other way, which I think people should do both, is to write a very, very detailed explanation of your relationship. And I know that it is private. People often don't want to share those intimate details, but those details are very important. So I help my clients write declarations. We basically interview them over the phone and help them type their declaration. And we ask them questions about, well, how was this person when you were dating? How did they treat you? When was the first time that you felt you were abused? What did that mean? What did they do? What did you do? And usually what happens is that people have a lot more stories about what happened in that relationship if you only tell, hey, this one time this person pushed me, that is not going to be enough to be a VAWA. The officer is going to need to understand exactly what happened in that relationship, not just what led to them pushing you, but is this a pattern? Because to be honest, you pushing one person one day, that may not be abusive, right? Like you might push somebody to the side one day and it might not be abuse. Abuse is a pattern, right? It's not just one, and it could be one instance if it's extreme, but for the most part, especially these that don't have police reports, that don't have physical, evidence, it's that it's a pattern of control, it's a pattern of abuse, manipulation, isolation, not letting people see their family, not letting them see their children. Like there's a million things that can happen in there, right? So that objective evidence, go to a psychologist, get evaluated, and write a very, very good declaration with all the details of your partner. Some people are afraid if that is going to affect their partner in the future. For the most part, a VAWA claim does not affect another individual in the future. However, it's important to note that if that person goes out and divorces you, marries another person, that person's also an immigrant and is doing paperwork, it's going to raise some flags to immigration about whether these marriages were real or not, right? That these people get married only for the immigration benefit. So it's very, very important for you to prove that that relationship was true, that this was a genuine relationship, and why the abuse has happened. Another thing that I would say here is that sometimes, and I have this, sometimes people are still living with their abuser. And so I have a couple that has been married for like more than 10 years. This US citizen will not do the paperwork for the spouse, even though he is permitted to do so. And we found out why, and there is abuse, but that is the father of her children. And she depends financially on this individual. And she is still doing a VAWA while living with him, right? She understands that she's been abused. She understands what's happening, but is choosing this in her life because of her personal circumstances. So it doesn't require for you to have been divorced already. It doesn't require for you to have been separated. There is an extra level of caution because this spouse, for example, doesn't know that she's doing her paperwork. We have a safe address, which we use with victims of domestic violence sometimes, or trafficking. So there are ways to do it. Okay. Don't feel bad because you got the RFE. It's just, an additional steps that you're going to need to take, but you can definitely prove it, even if there's no physical evidence, police reports, or arrests.
Thank you so much, Attorney Bilbao. So from Ahmed, he's asking, I received an RFE with a deadline, but getting documents from my home country will take longer. Can I request an extension, and how should I handle this?
Yes, Ahmed. So this is a prime example of what we were talking about earlier. When you get that RFE deadline, that is usually it. You can certainly try to submit that to immigration saying, hey, I have submitted a request for this. They told me it's going to be 30 days. Here's my proof that I submitted it. I'm asking for a 60-day extension to give me time to receive it and, send it back to you. But for the most part, that officer is not going to accept that and is going to just deny the case for failure to provide the evidence on a timely request. So they do not have to provide you with an extension. Usually, and this is the logic behind it, when you apply for the benefit, you should be approvable, meaning that the evidence that you submit at the beginning should be enough for the government to approve your application at its first glance. That is usually the requirement. So if you're missing evidence, the government is giving you the courtesy of giving you this additional time already. They don't have to extend that. They can deny, and they usually will. Now, one thing that you have to be careful with here, Ahmed, is that we are, yes, USCIS is now issuing notices to appear. So a notice to appear is the referral from your case into immigration court where you're being placed in removal proceedings. So if you are denied an immigration benefit and you do not have underlying status, you need to be very careful. You are likely going to be referred to court into deportation proceedings. So if there is another way to prove the document that you need or another way to get it, I would try to do that as fast as possible, because it's very possible you will be denied. They likely won't give an extension.
Very nice having you here, Attorney Bilbao. That will be the last question that we'll be entertaining for today. Thank you so much for breaking this down, this difficult topic, in such a clear and practical way. Your insights provide real hope for immigrants who may be facing one of the most stressful moments in their immigration journey. To our audience, thank you again for joining us. We hope this conversation has given you clarity on responding to requests for evidence and notices of intent to deny. Don't forget immigrationquestion.com. You can ask your immigration questions for free and get in touch with a licensed attorney who understands your case. You may also be eligible for a free confidential consultation, so head on over to www.immigrationquestion.com and sign up today. And if you want to revisit the session or share it with a colleague, please feel free. You can catch the replay on Spotify. Just search Borderless Talk by immigrationquestion.com. Join us again on Friday for another enlightening conversation. You won't want to miss it. Once again, thank you so much, Attorney Bilbao. We can't wait to have you back here again.
Thank you, Max. This was very fun. Can't wait to come back.
For sure. Looking forward to it. Have a lovely rest of your day.
You too. Thanks.
Thank you.